I read the relevant paragraph of the next P1 and P2. Action has to be taken against the guilty officers for making erroneous calculation sheet in the assessment work of land property and causing financial and administrative irregularities. This letter was sent by the SDO Revenue Alert. My name is on number 2. I was Tehsildar for 3 months. There the count mailed the same letter mailed to P2. SDO Revenue has sent the announcer P2 to the Tehsildar that erroneous calculation has been done by them. Now I come to the page number mail 44 mail. We were posted there from the 29th October 2020 to the 30th of January 2021. This is our first order sheet 1,412,020. On the 29th October 2020, the calculation sheet of the properties was prepared, under which houses, population, land, vehicles in the presence of villagers were calculated, and we sent this order sheet to the revenue. Come to the MELD, that continuation order sheet is on page number 55. The MELD is about land acquisition. It is dated the 6th of January 2021. A total of 264 claims and objections were received, and a report was submitted after investigation in the presence of Executive Engineer, Civil Chhattisgarh State Power Generation, Revenue Department employees and the applicant. The claim objection was resolved on the spot. So-and-so day MELD order, only after that there is an order of 2010-2021, in which the objection was resolved. After that we were transferred on the 30th of January 2021. Now an award is passed in it, Mela, and that award is challenged by Chhattisgarh Power Generation Company. My Lord, now annex the annexure PP5. My Lord, now this is page number 73. This is the order of the collector, MELT, the award which was passed for land acquisition. I read the River Paramel. On the basis of the above facts, I conclude that the section officer Gergoda has done the valuation of the applied land as per the law. An error has been made in calculating the additional amount under Section 30 of the Act 2013. According to the said provision, the additional amount should have been calculated for the period of 6 months from the date of publication of the advertisement to the date of order, and not on the date of commencement of proceedings in the case 254/2018, because the application came on 254/2018 and they calculated from that day. Therefore, an error has been made in calculating the additional amount for 32 months. Therefore, the section officer GAR is remanded with the instruction that a revised order should be passed on the applicant's calculation from the date of publication of the advertisement to the date of order under the Act 2013. This order was passed because we were the Tehsildar there. We were there for 3 months. Now I have told the proceedings of our 3 order sheets in the order sheet. After this, in the mail dated 2000 January to July 2025, we were issued a show cause notice. I have mentioned P8 mailed.
Page number. Page number is mail 100.
Read the relevant parent acquisition related BOO. The officer, employee who did the wrong calculation of the property is mentioned. Your name is in the category of error of diligence, wrong calculation and evaluation. So give your reply. Explanation. We have submitted our reply behind this that we were there for 3 months and we had prepared the order sheet of 3 months and sent it. Now I just now understand that the collector of P1 and P2 has given an order to the SDO. The SDO has ordered that an FIR should be filed against them. Against so many people, our name is too in this. So since departmental inquiry is going on, after that the collector gave this order. Whereas the order of the collector sir himself is that the rent sorry interest which was excess for 32 months should be made 6 months. Within 6 months, the award for the 6-month part has already been passed. So has an FIR been registered against the accused in this? No, no FIR has been registered. If an FIR had been registered, then Meerut, whereas we are Tehsildars and there is also an order of Honorable DB Sir that the Tehsildar, Revenue Officer or Protectors under Judges Protection Act, Section 2 and 3, no FIR of any kind will be registered against any judicial action taken by them. Departmental inquiry is going on. We have no objection to it. But if an FIR is registered, then there will be a new litigation. FIR will be registered. Police will arrest and then there will be suspension from the job as well. Arrest will happen. I had only one request, that the proceedings of the FIR should be stopped. This is a judgment, man, and there is also a judgment of P.K. Gupta ji in this. It is of an able single bench. Its last paragraph was probably not accepted. However, a judgment has been passed recently.
You have come and the writ petition has come into service.
That is why if an FIR was lodged in this, I would have to go to CRMP or WPCR. I have challenged this. I have also challenged the show cause notice issued to me, because my tenure is only of 3 months and I have not done any work in which there is any error, and when the error has been corrected, I am getting a notice of 300 rupees for that. Departmental inquiry is being done. Then, the proceedings of the FIR are going on. My only request was that the letter of FIR issued by the collector and SDF should be stayed. No, the biggest thing. Because my role is completely limited. I have not passed any final order. Nor have I done it. There can be an error in the calculation of the property. The only error is that the interest part of 32 months was added, whereas the collector said that it should be for 6 months. The interest part of 32 months from the date of publication has been removed. A new ward has been passed with the interest part on the basis of 6 months. My lord, so this is a graveness, my lord. If an FIR is lodged, my lord, then for that the petitioner, my lord, he will travel the entire life, my lord. Did you get time? Time seeking instructions, my lord? Come on the 100th, you have taken instructions. The hearing on the 9th is complicated. I will not give a stay immediately.
Madam, this is my judgment.
First of all, that the order which you have passed, I have
not done it in judicial capacity. No judicial, there are 2 types of orders. If the revenue authority passes any order in the master court, then it will be considered in judicial capacity, this agreement. Here, they had to find the calculation sheet. From the administrative point of view, they went and noted the calculation sheet. He was not performing any judicial function. He did not pass any
judicial order. He did not
pass any judicial order. Then how will protection be
provided? Because the proceedings which have happened are
not for everyone. It is written in them
that if a collector like you passed the award, this was in judicial capacity, he got protection. But you go to the administrative side, roam around, inspect the spot and go and add it to the calculation sheet. Now if you have done something wrong there and any action is being taken, then show me even one ruling in administrative capacity, that he has protection. My boy, that is not the case, but my boy, the appeal which was made to the collector, the appeal of the entire award, in that the calculation part has been 6 months instead of 32 months, so instead of that the award has been passed, mail.
At that time you are not working as a judge, made this as this is.
A true mail, but we are having the mail, the post of the Tehsildar mail, this proceeding in acid by the SDO revenue mail is a yes. After getting the reply from them, I will
mail. If someone's
house is demolished without any order, then there will be a criminal FIR. No, in that. And what is this calculation paper? The calculation paper which was said in an administrative manner. Administratively you went to the spot,